I'm Rob Sterne, founding director of intellectual property law firm Sterne, Kessler, Goldstein Fox. Today I want to talk to you about a critical topic in the current patent office litigation landscape: patent eligibility challenges in post-grant proceedings after the America Invents Act. Patent eligibility is a big issue in U.S. patent law based on recent U.S. Supreme Court and Federal Circuit decisions. In the not-too-distant past, the assumption was that patent eligibility in the United States was very broad, and to put it in Chief Judge Rader's term from the Federal Circuit, was just a coarse filter in the patent examination process. But that has changed with recent decisions involving a broad range of technologies, such as methods of doing business, software-related inventions, compositions of matter, genes, and diagnostic testing. And many emerging technologies will be implicated by this issue. The new contested proceedings will play, in my opinion, a big role in the legal area of patent eligibility. So let's turn to inter-parties reviews. Inter-parties reviews are allowed to consider only patents and printed publications prior art, and cannot entertain directly patent eligibility under Section 101. However, integral to the entire proceedings is the claim construction ruling of the board that is required. Now, in making claim construction rulings, the board has to determine if the claims are clear, and they also are looking at the claims from the perspective of patent eligibility. So while the board cannot directly address patent eligibility under 101 in IPRs, my guess is that they will make note of issues involving eligibility in footnotes in their decisions in IPRs. Turning now to the covered business method review. Here, the statute specifically allows for challenges of patents that are part of the covered business method review process under the ground of patent eligibility. The first filter for CBM is whether the patent is implicated by the CBM process. And any patent dealing with methods of doing business that does not fall within the technical invention exception, which has been determined to be very narrow, are implicated by CBMs. So CBMs seem to be available for a broad range of software-related inventions, as well as methods of doing business that use computers. Now, CBMs will directly address statutory subject matter issues, as they have from the very beginning of the CBM process. So I think it is fair to say that CBMs will be a driving force at the USPTO, as well as in the patent law in general, on the issue of statutory subject matter, as CBMs address this issue going forward. When the new post-grant review becomes available for AIA patents, 101 will be available for all the patents that are subject to post-grant review. So in sum, I think we will see the Patent Office become the driving force on the metes and bounds of patent eligibility through these contested proceedings as they go through the board trial process and then on to the Federal Circuit for review. Thank you very much.